Let's say that you have a case where you either have received notice that a default order has been entered, or you are the petitioner in a case where a default has been entered. What are the implications of that default order? What can be done to undo or appeal that default order? And what happens generally when a default order is entered? So let's say you have a family law case, whether it's a divorce, an original suit affecting the parent-child relationship, or a modification. And a hearing is set and the other party does not appear for the hearing, whether you are the original petitioning party or you happen to be the responding party, and a default order gets entered. Let's start with, what is a default order? A default order is what is entered when one party does not appear at a hearing, typically the party that is responding to an original petition or a particular motion. The default is entered as a placeholder to enter the terms of the order when the other party has not filed a formal response or has not otherwise appeared to present their case. Thus, if you are the petitioner in this type of case, you are entering the default order that would include the terms that you want. So let's say it's a suit affecting parent-child relationship, and we're talking about child support, we're talking about conservatorship, and we're talking about possession and access time. You, as the petitioner, would have the judge sign an order that includes terms for all of these things that are your ideal terms. So you want the respondent to pay maximum child support, you want the respondent to have the minimum visitation and access, and you, as the petitioner, want the absolute most latitude with the rights and duties as possible. Congratulations, you have an order that says exactly what you want it to say. Now, the other party is going to need to be notified of the fact that an order has been entered. At that point, that party has the opportunity to file a request to modify the terms of that default order. If the other party in a divorce does not file any sort of response for 60 days, which is the waiting period to finalize a divorce, then on day 61, technically, theoretically, you could enter a default final order that also includes all of the terms that you would want, both for division of property and also for child issues if there are children in this divorce. In terms of a suit affecting parent-child relationship or a modification, which primarily would most likely be relating to child issues, you also would be able to enter a default final order if the other party never filed an answer. However, there is no 60-day waiting period. So if you file a original suit affecting parent-child relationship or a modification of either a divorce decree or an original suit affecting parent-child relationship, and the other party does not file an answer for 20 days, then on day 21, in theory, you could absolutely have a judge sign a default final order, which would, again, include all of your terms that you would want included in that order. At that point, the other party, again, would be notified by the clerk's office that a final order has been entered. It is then up to that party to contact the clerk's office and request a copy of that default order. And then, from the time that the default order was signed by the judge, that party has 30 days to file a motion for new trial, which essentially reopens the case completely and allows the judge to consider whether a new trial is actually appropriate in this case. So the judge is going to ask, well, why didn't you file an answer in the first place? In general, we see that judges give a lot of latitude to parties that are requesting new trials because no judge wants to be overturned on appeal for entering an order that another party has not at least reviewed or had any part in participating in. If you are the party that was subject to the default order, so if you are the responding party that did not appear or did not file an answer, then absolutely take advantage of that 30-day period to file that motion for a new trial if the default order is a final order. If we're talking about temporary orders, what basically that means is the other party was notified that a petition was filed or a modification was filed, a hearing on temporary orders was set, that that other party would have had to have been notified that a hearing was set and then deliberately either not filed an answer again or just did not appear for that hearing. In the event that default temporary orders are entered and the responding party is then notified that default orders have been entered, they can then file a motion for additional temporary orders or a motion to modify the temporary orders in order to essentially try to redo that hearing or try to undo the terms of that default order. So a default order isn't necessarily going to be the be-all, end-all final order in a case if the other party decides that they do want to appeal that order in some way. And when I say appeal, I don't mean the formal appeals process with the Court of Appeals, but I mean in the terms of temporary orders, filing a motion to amend the temporary orders, to modify the temporary orders, or for additional temporary orders. And then in terms of a default final order, filing a motion for a new trial, assuming that we are still within that 30-day window. So if you are the petitioner and you do have a judge enter a default order for you, again, congratulations, you've got what you want. Don't rest on your laurels. It's possible that the other party will be notified that a default order has been entered and try to do something about it. However, while the default order is in play, you have absolutely all of the rights within that order, and every single order that the judge has signed is in place. So child support that's ordered is child support. The rights and duties are going to be what the rights and duties are. You don't need to worry about exercising your rights per the terms of that order. But do be sure to speak with your attorney about the implications of the default order. What happens if the other party, if the responding party does decide to appear and try to redo or undo the terms of those temporary orders? Thank you for watching. If you have any questions or comments, please leave them down below. Otherwise, you can find us at familytexas.com.